I'm Joel Ankney. I'm a lawyer who helps people buy and sell small businesses, and I'm the author of the book, Here's the Deal: Everything You Wish a Lawyer Would Tell You About Buying a Small Business. Earlier this year, I was invited to speak to the Entrepreneurship Through Acquisition class at the Columbia Business School about the legal process of buying a small business. And I'm making this video to share with you the presentation that I gave to the ETA class because I think the information is relevant for anybody who's thinking about buying or even selling a small business. The first document a buyer will be asked to sign typically will be a confidentiality or non-disclosure agreement. They're called confidentiality agreements. They're also called non-disclosure agreements or NDAs. It really doesn't matter what they're called. They have the same purpose, and that is the seller wants to protect the confidential and proprietary information that it's going to be disclosing to the buyer. And so the seller will ask the buyer to sign this confidentiality or NDA. There are a couple of things to look out for when you're signing a confidentiality agreement. You want to make sure that it's mutual. In other words, that it protects information that the buyer is also disclosing to the seller. For example, if a buyer is asking for seller financing, the seller may want to see financial information from the buyer to determine whether the buyer is creditworthy. You also want to pay attention to the definition of confidential information and make sure it fits the transaction, that it fits the industry that you're in or that the seller's business is in. You also want to make sure that it doesn't have any conditions in the definition that might create problems down the line. For example, I've seen confidentiality agreements that indicate or the only type of information that's confidential is information that's actually stamped with a confidential stamp. That's too limiting for me. There's so much information that flows that it would be difficult to make sure that everything has a confidential stamp on it, and you don't want to lose confidentiality protection just because you forgot to put a stamp on something. Also, I like to make sure that the confidentiality agreement pertains to information that was disclosed before the confidentiality agreement was signed. We don't want to get into a situation where information was disclosed prior to the signing of the confidentiality agreement and then have somebody, for example, a buyer, argue that that information doesn't get any confidentiality protection. And then finally, I'm looking at the duration of the confidentiality protection. Typically, the confidentiality agreement will indicate that protection lasts for 3 years or 5 years from the date of the agreement or from disclosure, but confidential information will be disclosed that really doesn't have an expiration date. And so we need to make sure that that type of information is protected for as long as it remains confidential. The other document that a buyer and a seller will sign at the beginning of the process will be a letter of intent. A letter of intent is for the most part non-binding. It's essentially a roadmap of the significant terms and conditions of the transaction. There will be some binding provisions in it, and those protect typically the buyer. The buyer wants to make sure that there's an exclusivity or non-negotiation provision in there so that the seller will essentially take the business off the market for a period of time. It prevents the buyer from getting into a bidding war with other potential buyers. We also want a binding provision in the letter of intent where the seller promises to continue to conduct the business in the ordinary course, to conduct the business as they've historically conducted the business so that the business doesn't drop off. There's the potential sometimes for sellers to feel like once they have a letter of intent in their hands that they can stop ordering inventory, that they can let employees go and not replace them, things like that. And we just want to make sure, as from a buyer's perspective, that we're protected against those types of things happening that could harm the value of the business. We don't want to get to closing and find out that the business isn't worth what we agreed to pay for. Another binding provision in the letter of intent will be the due diligence provision. Again, this will give the buyer a period of time to take a deep dive into the information about the business, the financial information, the operations of the business, etc. During the due diligence period, the buyer is going to use that information to evaluate whether or not he or she wants to continue with the transaction. Everything else in the letter of intent should be non-binding. Thank you for watching my presentation. If you have more questions or want to learn more about the process of buying or selling a small business, you can see my contact information here on this last slide. If you want to buy my book or listen to the audiobook, you can find the print book on Amazon and the audiobook on Audible. I also maintain a blog at my website, so if you have other questions, you might look there first to see if you can find an answer there. Thanks.